equal treatment under the law. That's all they have to say. You have to treat me as a company. You have to treat me equally as you treated Kroger. What makes Kroger so special? By saying that alone, everything that Kroger did to me is now legal to do to you. This is Yaku. Title VII has been overturned. Title VII, the law that protects you from discrimination in the workplace. The law that you use to sue a corporation for discriminating against you. It has been effectually overturned by the Fifth Circuit Court of Appeals, using my case against Kroger, Rylander versus Kroger. The legislation words that in order to protect yourself as a company from losing in a lawsuit, the first order of business in your protection, in your defense as a corporation, would be simply that you fire them for a legitimate reason. So the law says that the corporation, the company, has to have a legitimate reason for firing someone, okay, to be protected from a discrimination suit. Kroger did not have a legitimate reason for firing me, okay? They didn't have any proof of the reason why they claimed they fired me. And to make matters worse is during the proceedings, the Supreme Court overturned the Chevron doctrine, allowing them to make up their own definitions using their own standards, where a federal law or a federal standard, a federal definition is available. The Fifth Circuit Court of Appeals disobeyed the Supreme Court. They allowed Kroger to use a make-believe reason for firing me, and claimed, this was the Fifth Circuit Court of Appeals claimed, that Kroger didn't have to have a legitimate reason for firing me. They only had to have a good faith belief, a reasonable belief that a company policy was violated. So now on the books, as it is this day, January 16th, your job can fire you, not because you violated a company policy, okay? But because they don't like the fact that you're black. They don't like the fact that you're a woman. They don't like the fact that you're disabled. They don't like the fact that you're old, okay? I mean, they don't like the fact that you're a white man. Yeah, they can fire you, and you know they're discriminating against you. Yeah, white men get discriminated against too, contrary to popular opinion. I saw a lawsuit. White men won a lawsuit against a company because they discriminated against him because he was a white man. So yeah, white men just don't exclude you. So here's the details. I was working in a warehouse. I was a forklift driver. Had two white Hispanic males looking down on their phone walk right in front of my forklift. We have a green line in the warehouse. It's called a safety line that every associate knows. that you have to look both ways before you pass that line in order to be protected. Okay? They wasn't paying attention. So me looking ahead, I had to swerve to the left to avoid running over them. And I came to a complete halt after I completed my move. Last minute quick decision. You know, I could have hurt those guys if I wasn't paying attention. Once they got by, I started my forklift back up, and it made contact with the bottom of the protective barrier of a cast iron stairwell that's inside the Kroger warehouse. Make contact, because I stopped and it started moving again. Didn't realize I was right underneath it. Boom, made sound, metal on metal. Of course, it didn't damage the stairwell. Can't damage the stairwell. So I looked at the forklift to make sure the forklift wasn't damaged. Forklift wasn't damaged. Looked at my load. My load wasn't damaged. I wasn't injured. No big deal. Okay? Kroger decided to call that an accident. Chevron doctrine. You can't call an accident a near miss. You can't call a near miss an accident if there's a definition. Well, OSHA describes what a near miss and an accident is. Have a definition for it. OSHA is a federal department of the United States government. Their definitions is what you make your determinations on. Kroger was allowed to call it an accident without submitting any proof that an accident occurred. Okay? So they lied about the reason. Of course, I brought this up in court, naturally. I studied law. So, naturally, I'm going to bring this up, not including the fraud that they committed. We're not going to talk about that. That's besides the point. But the fact that your reason for firing me was illegitimate, you can't win by summary judgment. Federal court allowed them to win by summary judgment, claiming that Rylander has no evidence, Rylander has no evidence, Rylander has no evidence, which is concealment. When you ask for documents to prove your case and you don't receive them, it's called concealment, which Kroger didn't give me any of the documents I requested. Any. File for sanctions, file motion to compel, all of that. Judge denied everything. Fine, no big deal, it's still concealment. Normally in any other case, the judge would instruct the jury to say, take everything that the petitioners say as being true, since the defense don't want to give up any of the documents requested. The judge didn't do that in this case because Kroger is a donor to the federal candidates. I can show you their donation list. You can look it up yourself, though. 930 million here, 930 million there, 930 million, 930. So it's pretty obvious they're going to have favoritism in the federal court. Okay? They hired some super lawyers to go against me. I'm not worried about no lawyers, man. I studied law. I was top of my class. Junior college, but, when you're doing something that you enjoy, it's easy to learn proficiently. We get to the Fifth Circuit Court of Appeals. Kroger makes the same argument. But listen, in the federal court, they didn't say that they had a good faith belief that I violated a company policy. That was something new that they made up to defend themselves in the federal court. Now, see, I mean, in the Court of Appeals. Now, see, you don't get to make up a new reason post-judgment after you've already won. You don't get to make up a new reason for why you initiated the adverse action in the first place. You don't get to change your mind in the Court of Appeals. Well, the Court of Appeals not only allowed them to come up with a new reason. Kroger claimed that they didn't have to prove that I was actually in an accident. All they had to do is have a good faith belief that I violated a company policy. The company policy would be reporting an accident as soon as possible, which they said immediately, which that's another flaw that we have with Teamsters. The only problem with that is we don't have any language that allows you to fire somebody for avoiding an accident, which is what I did. It's called a near miss. A near miss means that an accident almost occurred, but it didn't. That means nobody was hurt. That means nothing was damaged. And at the least, production didn't stop. Because, stopping production, the assembly line stops moving, you can call that an accident too. Okay? Neither one of those three things occurred. So you can't, by federal definition, you can't claim it's an accident. By federal definition. In the policy that Kroger signed and agreed to, you don't have a right to fire someone unless it's actually an accident. Teamsters. Where's Teamsters in this? Yeah, they're next on my list, don't worry. Because they didn't represent me. They didn't represent me at all. In fact, they told me they can't take up my case. They can't get involved, that's what they said. They can't get involved in my case. So them not getting involved as it stands at this point, Title VII has been overturned. I don't think you guys understand how this works. Just like Roe versus Wade was overturned just by one person's decision, this is exactly what just happened to your protections from discrimination. Title VII. Because now, here's what's happening. Now it's law. Case law is law. Okay? Case law is law. Rylander versus Kroger is case law now. And you're going to see where the Fifth Circuit Court of Appeals said that Kroger didn't need proof that there was no accident. All they needed was a reasonable belief that I violated a company policy. So if Kroger can use this, your company can use it too. Because it would be inconsistent with due process to allow Kroger to get away with it and not allow your company to get away with it. If Kroger didn't have to have a legitimate reason, then your company don't have to have a legitimate reason. Yes, you know they're discriminating against you. They called you the N-word, okay? But they fired you and falsely claimed that, I don't know, you left some water on the floor and it could have injured somebody. That's why they fired you, because you didn't get the water up. They can fire you claiming that they believed that you were going to be late, which would violate a company policy. You wasn't late, but they fired you for that. Now you go hire you a lawyer, you finna file a discrimination lawsuit. You know they hate women. It's misogynistic atmosphere. But they fired you because they say they believed that you was going to be late. They believed that you were going to violate a company policy. That's the reason they fired you. You go hire you a lawyer. You'll say, oh, no. We don't have to turn any proof that she was late, because Kroger didn't have to turn any proof that Rylander, actually did what they claim he did. They didn't have to have no evidence. So if I was able to go through this without Kroger having evidence, then the Fifth Circuit Court of Appeals and the federal court has to dismiss your case with them having no evidence you were ever late. Case law is law. Because Kroger was able to get away with it, now your company has to be able to get away with it, because it would be inconsistent with due process for them not to. That's what happened to your protection. They don't have to have a good reason. They don't have to have evidence that they're telling the truth. And listen, here's the worst part. Because, look, I'm not bragging. I'm good at what I do, okay? I'm good. You guys can read the documents. Any of you lawyers out there, you guys go look at my documents, man. You see what this argument is about. It's one-sided. They have no case, okay? The corporation can expect the judge not to consider any of your arguments. They can treat it like it's a Rule 91A motion to dismiss in federal court. Okay? Rule 91A motion to dismiss demands that no evidence be used to make the determination on whether you're going to dismiss the case or not. Rule 91A motion to dismiss. They've effectually turned any Title VII discrimination case that is determined by summary judgment into a Rule 91A motion. They didn't pay attention to nothing that I said. Look, I'm telling them in plain language. Kroger knows the difference between a near miss and an accident. They have to. It's not like they didn't know that a near miss and an accident ain't the same. They're OSHA regulated. This is an OSHA regulated facility. You have to know this. It's required by law. Kroger also know that we don't have any near miss policy in Teamsters where you can fire me for avoiding an accident. They know this. But they did it anyway. Because, look, just to be honest with you, I'm going to just tell you the truth. Everybody there knows this. The Kroger warehouse, the one I was at, probably all their warehouse, it's an age-oppressive atmosphere. Okay? You're not going to make it there too long as an older person. Man or woman, you're not going to make it there. Unless you've been there for, since your 20s. Okay, not as a worker. On the floor? Oh, no. No. They'll hire you. But 2-3 years down the line, trust me, they're going to start making up reasons to get rid of you. They'll do illegal stuff, which they did to this other guy, poor Mr. Willie. Gosh, man, I really feel sorry for that man. They did him bad, Mr. Willie. If you're watching this, man, look, I'm sorry for what happened to you. I'm trying to do something, okay? I called you, you didn't answer. But, yeah, no, I know what they did to you. I know what they did to you. They went there and changed your numbers. I know. All right? But you know the real reason why they tried to get rid of you, because your age. And all the other people who's going through this at the Kroger warehouse. Look, this is well known. It's not, I'm making this up. It's not alleged. Okay, I'm the person they did it to. This is not alleged. I filed the lawsuit. Okay? They call it prima facie, but it's prima facie, okay, because it's a Latin word, but establishing prima facie. It sounds country. Establishing prima facie, as they call it. You just have to prove that, someone younger, in my case, someone younger replaced you, or someone younger was treated differently. Well, that's simple. I mean, I had a nephew who worked there. He actually injured himself. Didn't report it at all. Okay? When he did come and report it, I think the next day or something like that, came in there limping. They just told, he told him what happened. He, injured himself on the job. They just told him to go home. He took a few days off, till he got better, then came back to work. The Teamsters policy says that you have to report an accident as soon as possible. Not the next day, as soon as possible. It would be sometime during that day. It might not be immediately, like Kroger claims, but, as soon as possible, as soon as you can. Finish your run, then go in there and report it. Okay? He was ready to testify. Summary judgment ended the case before my witness even got a chance to speak. I don't have to depose, do a deposition. I don't have to depose my witness just to avoid a summary judgment. Any lawyer who thinks I do, you're wrong. Okay, go look it up. A New Day on Summary Judgment. Look that up. Okay. So you can't say that I didn't have an argument. And since I asked for a jury, that argument is supposed to be made in front of the jury. Okay? Not allowing my witnesses to speak allow Kroger's claim of no evidence to be rewarded. So you concealed documents. Federal court judge didn't do nothing about it. You ignored my witness assertions. Federal court didn't do nothing about it. I explained the same stuff to the Court of Appeals, including the fraud, which I'm not going to get into that, but because it's extrinsic fraud, it's obvious. I have this right now in the state court, declaratory judgment. But neither court did anything about it. What makes it bad for you is it's case law now. It's the law. So any company can use these exact same parameters, okay, against you right now. Right now. Yes, you was discriminated against. But now they can withhold the evidence that you asked for because Kroger was able to withhold it. They can lie about the reason because Kroger was able to lie. But I got a union contract. You can have a union contract too. And they can ignore the wording in the contract and use whatever definition the company gives. They can legally do that right now. Because if they don't allow your company to do it and allow Kroger to do it, it's inconsistent with due process. Equal treatment under the law. I had to let you guys know because I've been fighting this for 3 years. And now it's in federal court. It's in a state court because the judgment is literally already void. It has to be declared void, though. But to do that, I got to get past the judge. Now, Kroger, obviously, they own the federal court judges. They own them. This is either extreme incompetence on a federal level, this either extreme incompetence, okay, extreme bias against me, because just let me tell you right now, they hate people who represent themselves. They hate us. Okay? It's not just racism. I know I'm a black man. I know. That's not just it. They hate us. Or it's corruption. Legal corruption, paying under the table. They don't have to pay under the table. They got lobbyists. Look, I can show you the list of their lobbyists. Every election, they donate millions of dollars. Kroger does. To these federal candidates on both sides. They don't care who wins. Because of that influence, Title VII has been effectually overturned. Every area that Title VII would protect you from, that require of evidence, the requirement of a legitimate reason, the requirement that you meet showing that somebody from a different demographic was treated better, the evidence that you met is now allowed to be ignored because my evidence was solid. And it was completely ignored in the decision. The judges can't force your company to have these things and allow Kroger not to have them. You understand? Equal treatment under the law. That's all they have to say. You have to treat me as a company. You have to treat me equally as you treated Kroger. What makes Kroger so special? By saying that alone, everything that Kroger did to me is now legal to do to you. The judge that I have so far seems very fair. She seems like she's, she seems like she's normal, not paid off. She's just a judge. She's not bought and paid for. Okay. We'll find out real soon, but I don't know, because, you can never know. I just hope that this is just a regular judge. I don't need no favoritism. I don't need you to do me no favors. The law speaks for itself. Just judge it as it is. If some kind of way they get to her, I'm going to have to take it to the Texas Supreme Court, and then from there to the Supreme Court of the United States of America. You guys have to do something. You have to stand up. Find some lawyers. They'll tell you what I'm telling you is true. Right now, as it stands, Title VII has been overturned.